This talk forms part of the St John's Chambers Commercial and Chancery webinar series. I'm going to be talking today about the changes which have been brought into effect by reason of the temporary insolvency practice direction, which came into force on the 6th of April this year. It will apply until the 1st of October, unless it is revoked sooner. The practice direction applies to all insolvency proceedings in the business and property courts and makes express that it should be read alongside judicial guidance, which has been issued thereunder. Now, in respect of judicial guidance, we have had three sets of guidance. Firstly, that from Chief Insolvency and Companies Court Judge Briggs, which was issued on the 7th of April this year, and that applies in respect of hearings in London. We then have that of Mr Justice Marcus Smith in respect of the business and property courts on the Western, Midlands and Welsh circuits. And we also have that of Mr Justice Snowden in respect of the business and property courts on the North and North Eastern circuits. There are three main things that are addressed within the practice direction. The first being notices in relation to out-of-court appointments under Schedule B1 of the Insolvency Act. The second being the listing and conduct of insolvency hearings at a time where in-person hearings are not taking place. And thirdly, the practice direction deals with the remote administration of statutory declarations in an insolvency context. Now, in relation to the first matter, that being notices in relation to out-of-court appointments, there are three different types of notices which come within paragraph 3 of the temporary practice direction. The first is a notice of intention to appoint an administrator, which is filed by a company or its directors. The second is a notice of appointment of an administrator, which is filed by a qualifying floating charge holder. And the final one is a notice of appointment of an administrator by a company or its directors. In relation to these three sets of notices, which come within paragraph 3 of the practice direction, the general proposition is now that those notices are treated as being delivered to the court at the date and time which is recorded in the filing submission email. And that filing submission email is in itself a term defined in paragraph 1 of the practice direction as being an automatic notification which acknowledges that a document had been submitted. However, there are two caveats to the general proposition that a notice is treated as being delivered at the time and date recorded in the filing submission email. The first caveat is that notices which are filed by a company or its directors using the CE filing system outside the hours of between 10 a.m. and 4 p.m. on a day on which the court is open for business shall be treated as being delivered to the court at 10 a.m. on the following day on which the court is open for business. So in essence, that means that if a notice is filed by a company or director at 5 p.m. on a Monday, it will be treated as being delivered at 10 a.m. on the Tuesday. The second caveat is that qualifying floating charge holders are not permitted to e-file notices outside of court hours, and they instead must rely on the usual process which is set down in rules 3.20 to 3.22 of the 2016 insolvency rules. Now, notably, there is an omission in relation to the notices which do come within the scope of paragraph 3 of the practice direction, and that is notices of intention to appoint which are filed by qualifying floating charge holders pursuant to paragraph 15 of Schedule B1. Now, there's no explanation given within the guidance to account for this omission, but presumably the result of this is that notices of intention to appoint administrators, which are given by floating charge holders, can still be filed outside of court hours, simply because that is a prospect which is contemplated by the Electronic Working Practice Direction 51.0. The practice direction also expressly states that the CE filing of documents remains subject to the review by court staff who may reject documents for other reasons. So presumably in accordance with the scheme that has been set up under paragraph 3 of the temporary practice direction, a document will be treated as being delivered at the time shown on the filing submission email, unless and until the court specifies otherwise. In relation to the second matter which is dealt with within the practice direction, that being the listing and conduct of insolvency hearings, paragraph 4 of the practice direction opens with all applications, petitions and claim forms, save for petitions for winding up and bankruptcy, which are to be heard before an ICC judge sitting in the Rolls Building in London, which were currently listed for hearing prior to the 21st of April, are adjourned. and those hearings are to be relisted in accordance with the provisions of subparagraphs 1.1 to 1.3 of the practice direction. Now, in essence, there are three categories of cases here. The first is that if the matter is not a petition for winding up or a bankruptcy order, which was to be heard before an ICC judge in the Rolls Building, then a blanket adjournment applies. However, the parties can apply to have the matter relisted if they consider it to be urgent. Here's where we look to the judicial guidance that's been given by Chief ICC Judge Briggs, Mr Justice Snowden and Mr Justice Marcus Smith, as their guidance contains definitions of what the courts will regard as urgent in the various business and property courts within the region. The second category of cases are petitions for winding up and bankruptcy orders. The blanket adjournment does not apply in respect of petitions for winding up and bankruptcy petitions already listed to be heard before an ICC judge sitting in the Rolls Building. In that respect, a temporary listing procedure, which is laid down in paragraph 7 of the practice direction, applies immediately. And in respect of petitions for winding up and bankruptcy orders on the circuits, those petitions will be listed when the regional business and property courts bring into effect the temporary listing procedure. And now, in respect of these hearings, Mr Justice Snowden, in his guidance, has noted that the courts on the circuits have only needed to adjourn a limited number of pending claims, applications and petitions of their own motion in response to the COVID-19 situation. And Mr Justice Marcus Smith has echoed that sentiment in his guidance in respect of the Midland, Western and Welsh circuits. Save for those adjournments, the regional guidance is that the temporary listing procedure, as it applies in London, will also apply in the regional business and property courts. The third category of cases are those non-urgent matters which have been adjourned, and in this respect, Chief ICC Judge Briggs has noted in his guidance that the ICC judge's listing will endeavour to list non-urgent business where possible, taking into account judicial, clerking and technological availability. He goes on to state that non-urgent hearings which have been adjourned under the temporary practice direction are intended to be relisted within 6 weeks from the 21st of April. And priority will be given to those matters over the listing of any new non-urgent matter. Now, in respect of the regional business and property courts, Mr Justice Snowden notes that, again, the courts have only needed to adjourn a limited number of pending claims. Those which have been adjourned or are hereafter adjourned can be relisted as soon as it's reasonably practicable, and priority will be given as far as possible to those matters over the listing of any new non-urgent matters. So they're really reiterating the approach that Chief ICC Judge Briggs has stated in respect of hearings in London. Now, in terms of the conduct of the hearings themselves, unless ordered otherwise, all insolvency hearings will now be conducted remotely by way of Skype for Business or other such technology as the parties and the court agree in advance of the hearing. And in the event that a judge determines that, for whatever reason, it's inappropriate to continue the hearing will be adjourned and a new hearing date and time fixed by the court. So in sum, we have three categories of cases that have been dealt with within paragraph 4 of the temporary practice direction. Firstly, matters which are not winding up or bankruptcy petitions, which were listed before the 21st of April, are being adjourned. But if they fall within the definition of urgency, the parties can apply to have that matter relisted pursuant to paragraph 5 of the practice direction. Secondly, we then have bankruptcy and winding up petitions. In respect of those, the temporary listing procedure set down in paragraph 7 of the practice direction applies. And then thirdly, we have non-urgent matters which were listed prior to the 21st of April, which were adjourned pursuant to the temporary practice direction. Those will be relisted either 6 weeks from the 21st of April in respect of hearings in London, or as soon as reasonably practicable in respect of the regional business and property courts. And the final matter that's dealt with within the practice direction is the remote administration of statutory declarations. These are usually required in the context of members' voluntary liquidation and during the administration process. The temporary practice direction does envisage that there may be issues which would arise as a result of the rules on social distancing, which prevent the physical presence of the person entitled to administer the statutory declaration. So in this respect, paragraph 9.1 of the practice direction acknowledges that where a statutory declaration is not made in person, this may constitute a formal defect in the appointment. However, paragraph 9.2 goes on to state that where it is alleged that the related insolvency proceedings are defective as a result, the court must not find that the lack of physical presence of the person authorised to administer the oath has caused substantial injustice. In turn, where an objection is raised along these lines, the court is permitted to declare the related insolvency proceedings valid pursuant to Rule 12.64 of the 2016 Insolvency Rules. So the practice direction envisages that statutory declarations are to be made by way of a video conference with the person that's authorised to administer the oath. The person authorised to administer it must attest that this route, i.e. a video conference, was used to administer the oath and the statutory declaration. And then the statutory declaration itself must state that it was made via this route. So I hope this has been of some assistance in helping you understand the changes which have been brought about by the Temporary Insolvency Practice Direction. If you have any questions arising, please don't hesitate to get in contact. We are still working, albeit remotely.